Good morning, Judge Kathree-Setiloane.
Chief Justice Zondo.
We are just waiting for all commissioners to be back. Is everybody back? Oh, okay. Okay. Okay, once again, good morning, Judge Kathree-Setiloane. Welcome.
Very much.
Welcome, and thank you for availing yourself for this session of the interview. As you know, this session happens because there is an order of court that said the commission must do these interviews afresh. So thank you for availing yourself. I see that you hold 3 degrees, BA, and then LLB and LLM, is that correct?
Yes, that's correct.
And one you got in 1988, another one in 1991, and then 1993. And you got admitted as an advocate after you had served some time as a law clerk at the Constitutional Court, is that right?
Yes, that's correct.
Yes. How many years did you practice as an advocate?
I initially practiced for about 8 or 9 years, and then I had gone across to Worksman's to work as an in-house counsel, so I practiced there as an in-house counsel, and then I returned to the bar after that. So there must have been about 12 years in total, 12, 13 years.
Yes. And during that period, it appears from your CV that you did a lot of cases as an advocate that got reported in the law reports.
Indeed, Chief Justice.
Yes. Please describe to us the nature of your practice at that time.
Yes, it was, when I started off, it was a public interest practice. I initially started off, while I was doing pupillage, I was also employed by the Legal Resources Center. In those years, the bar gave me a special dispensation to both serve, to both work at the LRC and serve pupillage at the bar at the same time, because the LRC was through my year of pupillage. So it really, made things very comfortable and easy for me when the LRC, at that point, the Constitutional Litigation Unit, decided to take me on as an employee and to allow me to also do pupillage at the same time. And I think a few other judges may have also had that opportunity in the past. I know Judge Nafsa was one. I know but Advocate Patrick Mshalano was another one after me, who also served his pupillage and worked at the LRC at the same time. So I had also previously worked at the LRC immediately after university for about 2 years. In those days, it was a fellowship program and not articles. So,
how much of your practice consisted of constitutional law matters, more or less?
I'd say a fair amount. When I say I was a public interest lawyer, I also did a lot of constitutional law, with the public interest angle. So I did a lot of constitutional law, both as an advocate and at the LRC before I was an advocate. Constitutional law lies at the heart of everything. So it infuses all aspects of the law. And I mean, I think my passion for constitutional law was actually, my passion was actually developed from the years that I spent at the LRC. Well, that was pre our constitutional era, but we were very bogged down in administrative law and administrative review and labour law at the time. But a large aspect of my practice was constitutional law at the bar. Yes.
Yes, and you were appointed as a judge in 2010.
In 2010, October 2010, and I acted from, I think, January 2010 for a full year before that. Yes.
Yes, and that means that you have about 10 and a half years of judicial experience, is that right?
Yes, I think I'll start my 11th year.
Sorry?
I will start my 11th year now in October.
Soon.
In October, end of October, my 11th year.
Yes, okay.
But if you take my acting experience into account, I think it's 12 years.
Yes, but also during the time that you have been a judge in the High Court, you have acted in a number of courts. You have acted in the Labour Appeal Court,
Yes.
Is that right?
Yes.
You have acted in the Competition Appeal Court, is that right?
Yes.
You have acted in the Supreme Court of Appeal, is that right?
Yes.
And you have acted in the Constitutional Court.
Yes.
Has that given you quite a wide range of experience?
Yes, it has. It has. And I think it's made me a far better judge. And I see that now when I go back, when I'm sitting in the High Court. The manner in which I approach matters is with a very different eye. You get a wealth of experience sitting in large benches, particularly the Constitutional Court, the Supreme Court of Appeal, the Labour Appeal Court. The experience, it just helped develop me into a far better judge, I think, and the ability to hone into the important issues and to focus on the important issues, and to write judgments differently than you would write judgments if you only had High Court experience. So I think across the board, it has really assisted me as a judge, and I actually feel with each year and each time I act in any of these courts, I come out feeling more competent and more confident and more at ease with the job that I have to do in the High Court. So I'm really very, very grateful to have been given all of those opportunities to have that experience across the board in all of these appellate courts.
Yes. Do you have an idea about how many reported judgments you have penned?
I think in total, probably around 60, I would think.
Around 50?
650 or 60.
50 or 60?
60, I'm not quite sure.
Okay. No, we don't need to have the exact number.
60. I think it's about over 60.
No, we don't need to have the exact number. Okay. We've got them here. And some of those are judgments you wrote in the High Court, others Labour Appeal Court, others Competition Appeal Court, others SCA, others Constitutional Court.
Yes.
Yes. Now, in terms of the work in the Constitutional Court, either in the Constitutional Court or in the High Court, have you had a chance to deal with matters where you have to declare legislation
search and seizures without a warrant. And this took place in the context of, almost 3,000 occupants of buildings in downtown Johannesburg. And we rendered that section unconstitutional, but we also provided Parliament with an opportunity to put in place, to remedy that in a year. That matter was heard by the Constitutional Court, I think, at the end of last year, November, December last year, I believe. As far as I'm aware, I haven't seen the judgment of the the Constitutional Court. I think it's still pending. I rendered legislation under the IPID Act unconstitutional. The Contingency Fees Act, we found that the act was not unconstitutional, and that also was upheld by the Constitutional Court. But there were matters where the Constitutional Court basically confirmed the order that we made relating to the unconstitutionality of legislation.
Yes. What kind of factors would you take into account if you were appointed to the Constitutional Court and you had to deal with an application for direct access?
Well, the question is whether it's in the interest of justice that the matter comes to the court, by way of direct access. I mean, is it a matter where you need to have the view of the High Court? So ultimately, it will revolve around the interest of justice and whether or not...
What kind of factors would you look for in deciding the interest of justice?
Yes, I mean, well, the one would be basically whether this is an issue that, for instance, evidence has to be led, and the matter comes to the Constitutional Court, direct access, and the Constitutional Court can simply not deal with that matter. It's, the High Court would have to firstly sit on the matter, listen to the evidence, and then give a judgment on it. I mean, at the end of the day, the interest of justice is such a wide concept that, are the issues sufficiently important, sufficiently pressing, for the matter to come directly to the Constitutional Court?
And a direct appeal, what kind of factors would you look for to decide whether to entertain a direct appeal?
Well, I mean, the question is, firstly, the question is whether it's, the court has jurisdiction. Is it a constitutional issue? Is it an issue that raises an arguable point of law? So jurisdiction becomes very important. I mean, even with an appeal, it's always better for the Constitutional Court to have a decision of the court that first heard the matter. An appeal, in an appeal, you first go to the court that gave the judgment, and you seek leave from that court. I mean, a direct appeal is completely different from confirmation of unconstitutionality. It's there's a hierarchy in our court system. If it's a constitutional matter, it can come directly. If it's not a constitutional matter, if it deals broadly with the common law, it should go via the SCA first, the intermediate court.
Okay, please just repeat that last point. I
said if it's a constitutional matter, it can come directly to the Constitutional Court. But if it's a matter where it turns on the law and not necessarily the Constitution, it should actually go through the SCA. It should follow the normal course in the High Court, the Supreme Court of Appeal, and then come to the Constitutional Court as the court of last instance.
If it's a constitutional matter, it doesn't have to go to the SA?
If they're also common law issues, I think it can go to the SCA. It should go to the SCA. The SCA has dealt with constitutional issues. If it deals with confirmation of unconstitutionality, then it would have to come directly to the Constitutional Court. But if it's a matter where the SCA has jurisdiction, then it must go through the SCA before it comes to the Constitutional Court. You shouldn't be bypassing our court system. I think there's the hierarchy of our courts, and it's important for a matter to proceed through all of the courts before it gets to the Constitutional Court, unless it's a matter relating to confirmation of unconstitutionality.
Thank you, commissioners. Yes, Commissioner.
Good morning, Acting Chief Justice Moimang. Moimang is my surname, Acting Chief Justice.
Yes.
I know it can be very difficult to pronounce.
Thank you.
Thank you. Good morning, Justice Setiloane.
Good morning, Mr. Boimane.
I just have two areas that I want to converse with you. The first one relates to the recent Concord judgment on the IEC matter.
Just 1 second, Commissioner. Am I the only one who struggles to hear commissioners sometimes when they are speaking? Maybe, but I see your mic is quite close to you, so.
I've just brought it closer
No.
to me.
Okay.
DCJ,
Yes.
there is no monitor next to you there. There are 2 monitors here by you that side. So I think when we adjourn,
Yeah.
you need to get a monitor that side.
Yes. Okay. Thank you. Thank you. Okay.
Thank you.
Thank you, Commissioner Malema.
Thank you, Acting Chief Justice. I just want to check with you. Do you think that the South African Constitution is a living document that must be informed by the conditions that exist, like the pandemic, or is it an absolute that must be enforced at all times, irrespective of the conditions that exist? I'm raising this question in light of how the court interpreted Section 159 of the Constitution on the term of a municipal council to say, it is irrespective as to whether there is pandemic or not, the term of a municipal council ends after 5 years, and within 90 days you must go to the election. Don't you think that the court should have been open-minded on the interpretation of this section?
I think the Constitution is a living document. It's a flexible document. It allows one to, when dealing with the rights in the Bill of Rights, when dealing with any other constitutional provisions, and testing the constitutionality of legislation, of executive conduct, etc. I think it requires a contextual approach. And so it's a flexible document. The court decided to go the route that the 5-year period had come to an end and the elections have to be held on a particular day. That was the decision of that court based on its reasoning. But I see the Constitution as an organic living document. And for me, context is very important. I mean, there's no one answer to the question you're asking me, but it's important in any constitutional inquiry to basically look at context and the times. And, 20 years from now, the Constitution may require interpretation that's right for that time as opposed for now. 10 years ago, the Constitution would have required a contextual interpretation or a purpose interpretation for that time. So as I see it, it's a living, organic document that will be informed by the context, basically.
Thank you, Justice Setiloane. The second one, on your recent judgment on the setting aside of the mining charter, don't you think that somehow it delays transformation, particularly given the monopoly within the mineral energy complex, but more than that, taking into account the fact that in Botswana, the government of Botswana owns 51% of shares in the Shwana company. And here in our country, we are still at
I'm sorry,
36%.
Commissioner. I'm sorry,
Thank you.
Commissioner. I might have missed something. I'm hoping you are not asking her about a matter which might go to the Concord at some stage, and if she is appointed to the Concord, you may be asking her to express an opinion on it.
I think let's allow her to express a view on that, Chief Justice. If that is the case, then I'm comfortable I'll be comfortable with the answer. Thank you.
Well, if you are asking, I may have missed something on a question, but if you are asking to express a view on a judgment that has been given, for example, by the High Court, that might go on appeal to the Concord, you might be putting her in a difficult position.
I agree with that advice, Acting Chief
Yes.
Justice. Let me reserve that question. Thank you.
Okay, thank you. No, so.
Thank you.
Yeah. I'm sorry. Is it Minister first? Or him first? Okay. Commissioner Bofo.
Thank you, DCJ. Good morning, Judge. Thank you. Yes, no, I just wanted to say first that I know it must be difficult for candidates like you who were successful last time to have to do this again. But the DCJ has explained that a court order is a court order.
Stand, yes.
Yes.
You must comply.
No, I think we owe you an apology through you, the other successful candidates as well. But I only want to ask you one question, which is this issue about acting in the Constitutional Court, the importance of that. I think we canvassed it with the previous candidate, and we all know that it's not compulsory. It's not a criterion that is in the Constitution per se. But what significance, in your own personal experience, would you place on that factor? Or maybe asked differently, how did that enrich or convince you yourself about your own suitability to go to that court, given the work that you've done, the givens that you've given? Would you have felt the same if you had not acted in that court, if you get the gist of my question?
Yes, if I can just start at the beginning. I think if I had not acted in that court, I would not have put my name up for a position in that court. I certainly would not. I think it would have been presumptuous of me to have done so without having the benefit of, spending time at that court. Like I said to Acting Chief Justice Zondo, the time that I spent there was invaluable. I have to say, of all of the courts that I've acted in, and I really enjoy acting in the appellate courts. But I was very sad when that 6-month period came to an end. And I remember sitting at the conference table and Acting Justice Zondo was there, and we were saying goodbye to each of us. And he said to me, both in respect to me and Judge Collopin, my colleague, he said, we were very happy to have the two of you in this court. You were a natural fit in this court. And that really made me feel good. I really, really enjoyed the manner in which we dealt with matters, in the manner in which we exchanged ideas, the manner in which we disagreed or didn't disagree with. It's all done on paper. Unlike in some of the other courts, nobody comes to your office and tries to impress on you on what position to take, There's nothing of that sort. You are left to your own devices. When you get there, one or two judges will take the time to come to you. They'll take you through the process, because the process that you follow in relation to matters and the whole decision-making process is very, very different from the Supreme Court of Appeal or the Competition Appeal Court or the Labour Appeal Court. So it's completely different. Judges take the time to come to your chambers to explain the whole process to you. And they do say to you that they're available to assist you with any query that you have. And for me, I really, really appreciated that, where in some of the other courts, you don't really get that. You just jump in at the deep end, and things are expected of you. And if you don't do things in the way that is expected of you, then that is treated as a cross against your name. Nobody comes to you and says, well, you should not have done that way, you should have done it this way. In the Constitutional Court, it's very different. I picked up no ill feelings, I picked up no animosity. If you were working in a very calm environment, everybody was collegial. when you disagreed with somebody, you disagreed on paper. You got the time to basically set out, in a memorandum to your colleagues why you disagree. And then you were given an opportunity to basically, make amendments to a draft, make suggested amendments. So for me, that was so important. It was also very, very different from the High Court, where, we discuss issues before we go into an appeal. We discuss issues when you come out of the appeal. In the Constitutional Court, when I was a clerk, I know they used to have post-conference hearings after every hearing. At the time that I was at the Constitutional
Judge
Court.
Kathree-Setiloane, I know I want to give you a fair opportunity
Okay.
to answer, but the answers should not be too long
Okay.
because we don't have all the time.
Yes,
But Commissioner Mbofu says he's satisfied.
Okay, thank you very much, Mr. Mbofu.
Thank you.
Thank you very much, Judge. Thank you, Mr. Chair.
Thank you. Then, Minister.
Thank you, Acting CJ, and good morning, Justice Tulano. I
Good
just
morning,
have
Ms. Minister.
two questions. One, it relates to the answers you gave to the Acting CJ on the issue of direct access and direct appeal. That you seem to say that the test is the same. Maybe I'm wrong, but I was surprised by that you did not mention exceptional circumstances when it comes to direct access.
I suppose I meant, in the interest of justice, I meant to also refer to exceptions. There has to be exceptional circumstances before. Sorry, I beg your pardon. Indeed.
Okay, yeah, I was surprised that you did not mention them
Yes.
because I thought they are in terms of the tests, is the most important.
Yes, it is the most
factors.
important. Yes. Sorry, I used
Okay.
interest of justice, and what I meant to actually say was exceptional circumstances. You're quite right.
Oh, okay. My second question relates to the matter that you handled for the lesbian and the gay and equality project. And on the issues of same-sex marriages. I want to, what could be your view for government in particular, given the current environment of brutal killings of the LGBTQI community? What do you think could be done that we do not have to wait for the courts to direct us to promote love, diversity, and tolerance in society for this community?
Yes. I mean, I do think it's a community that has been treated badly, that are still subject to discrimination. We have a whole framework, a legal framework in place and a policy framework in place to basically deal with violence against women, violence against members of the LGBT community. Some say that framework is not sufficient. I think we can still work within that framework, but I think there has to be, on a broader level, there has to be education around the rights of these communities, and that's the only way there's going to be full acceptance. If society is made to understand that, like all other members of heterosexual members of society, people with differences from the LGBT community have the same rights and should be given the same protections. I think government can do much more in terms of its policy framework. I think government can do much more working, through members of parliament in their constituencies to basically educate society, educate communities on LGBT rights, and that will lead to a proper acceptance of any persons that come from marginalized or minority groups. I think our court staff, I think the police, all have to be sensitized around issues of violence, and this relates both to violence against women and particularly violence against LGBTQ women. I mean, I think when it comes to violence against women and violence against members of the LGBT community, I think our numbers exceed the global numbers, I think, by 5 times. You know, I mean, I think that's how drastic the problem we face with violence against women and violence against members of the LGBT community. So I think government, together with civil society and the courts, I think, have to work together in order to constitutionally entrenches the rights of LGBTQ people. But I think if you have this coordinated approach with all of these 3 groupings, you know, you can, in time, ensure that violence is eliminated completely against women and members of the LGBT community. And women especially, lesbian women especially, have become victims of violence, which is really very, very sad in this day and age of our constitutional dispensation.
Thank you.
Thank you, Minister. Deputy President Betzer.
Thank you, Acting Chief Justice. Good morning, Justice Kathree-Setiloane.
Good morning, Mr. Justice Betsy.
My first question to you will be in the form of a general proposition. And it is this: you know, collegiality amongst judges conduces to a healthy work environment, and lack of it is a catalyst for a toxic work environment. I just want to know from you first if you do subscribe to that general proposition, and 2, whether you scrupulously subscribe to the principle of collegiality amongst judges.
Justice Betsy.
Thank you. And my second and last question to you, looking at one of the Constitutional Court judgments in SOS Support Public Broadcasting Coalition and 2 others versus South African Broadcasting Corporation Limited and others. It's a judgment that you penned, and mindful of the fact that the primary responsibility for ensuring that a judgment is produced expeditiously rests with the scribe. Can you share with this commission why this particular judgment took slightly more than 10 months to deliver?
Yes, sir. This judgment was, we had heard argument in this judgment at the end of, right at the end, it was one of the penultimate hearings of the court in November 20, the year that I acted there, I think it was November 2017. During December, there was new correspondence from the parties, and they wanted to lead evidence on a whole number of aspects. And I then had to produce memoranda in that regard to my colleagues, which this sort of came in around Christmas, mid-December, I remember. And I had already started writing the judgment in December of 2017 during that recess. Yes, so there was the issue of wanting to lead evidence after hearing of the appeal. I then had to produce memoranda, and I think in January we considered that. My colleagues considered that and came back with the responses. We decided we weren't not giving them a new hearing, that we were going to basically deal with it in the judgment, so I had to take that into account. I then went back into the High Court, and in the last week of recess of the High Court, while I was busy with this judgment, I was in urgent court. So I had a particularly heavy urgent court because it was the last week of recess, and I needed time, I had a number of reserved judgments from urgent court that had to get out urgently. So that took me, I think, into February, when we started term, and I think I was in term for 1 week when, in terms of the roster, I was back in urgent court. So I had all of those commitments in urgent court again, which in Johannesburg, urgent court gets incredibly busy. I was then busy during the April recess. I then spent time on the judgment, and at the same time, I had Competition Appeal Court hearings. I remember at the beginning of that recess, but the second part of the recess and a week or two afterwards, I spent completing this judgment. There were a number of issues in the judgment. It was a highly complex matter, and there were two lots of evidence. The one lot of evidence we had to consider was whether we grant them leave to adduce new evidence at the point that we were hearing the application for leave to appeal, and the second was whether we allowed them leave to adduce new evidence after the application had been heard. I was still busy. I think at that point, just immediately after the April recess, and after I had finished my competition matter, I had then submitted the draft to the Constitutional Court. I had not heard from the Constitutional Court until about June or July of that year. So I didn't get feedback for them for at least 4 months on the judgment. When I spoke to Judge Jafter, he said to me, unfortunately, there have not been any comments yet. None of the colleagues have commented as yet. So I waited for them to come back to me. In end of June 2017, I had a tumor on my ankle, and I had to go in for an urgent operation to have that removed. It was then the recess, and I was recovering from the operation during the recess, when I think towards the end of that recess period, and while I was recovering, I then got a call then I received a draft, then I received comments from the judges, and I then worked on made the necessary revisions, and I sent it back to the Constitutional Court. They then conferenced on it, and then it came back to me, and I think within a day or two, we then produced the judgment. I then let them have my final judgment.
Through you, a follow-up, Acting Chief Justice. So the short answer to my last question is that the long period of gestation that finally bred this judgment was not attributable to any dilatory conduct on your part.
Absolutely not. Absolutely not.
Thank you, Justice Kathree-Setiloane.
Thank you.
Thank you,
Thank
Acting
you,
Chief
Justice
Justice.
Thank you. Then Commissioner Mapisa Ngakula.
Thank you very
I
much.
think she must mention that their judgment was against her.
Yes, it was. And I can assure you, I can assure you, DCJ, that it was one of the hardest ones on my part.
Yes.
But we did well. Thank you. Thank you very much, Judge Setiloane. And your CV talks to somebody who always advances the transformational agenda wherever you've been, be it quality of women, mentoring, and of young attorneys. And I would want to know, though, what do you think should be the attitude of judges who are in the Constitutional Court in educating society about some of their groundbreaking judgments? Yeah, I'm talking about society. I'm not now focusing on the legal fraternity. I'm talking about us who are sitting here. How do you think, because half the time when you find that indeed there's a groundbreaking judgment which was made X number of years ago and you're not familiar with it, how, as you move into, if you're appointed into the CC, how do you think this constitutional court should do that, but also promote the Bill of Rights of the people of South Africa? The Bill of Rights of the people of South Africa, because it's always about constitutionality, but you hear very little about the promotion of the Bill of Rights of the South African people. Thank you very much.
Yes. Yes, I mean, I think educating the public on the Constitution is an important project. The rights in the Constitution have to be realized and have to be lived out by members of society. And unless members of society are aware of the workings of the Constitution, of the rights, of their rights that they can invoke, the Constitution then becomes a useless document. So I think it's important. I mean, I think when I was a clerk at the Constitutional Court in the first year, at the inception of the court, the one thing that we proposed was that the clerks actually put together a summary of the case, a pre-hearing summary, a post-hearing summary of the case. And that was actually directed at the press, so the press are not confused. But I did see over the years that members of the public also benefited from those summaries. But I think much more has to be done. I think perhaps the Constitutional Court can, from time to time, have road trips where, there's nothing wrong with judges basically going out into society, spending a day in Soweto, spending a day in Alex, in the same way as NGOs do, just basically talking about their judgments to the people, educating them. But, I think it demystifies the court, it demystifies the Constitution. It brings, one's rights, makes it more realizable. So I think you could have that. You could have, once in 6 months or once in a year, judges basically making themselves available in a town hall to talk not about matters that they're currently dealing with or aspects that they may deal with in the future, but past judgments, the important judgments of the past and how that impacts on society. I think, there's a wealth of information amongst the clerks at the court. You could have a roadshow of clerks, during the recess, where clerks can join members of NGOs and carry out this educative process. So there's so many different ways of actually bringing the Constitution closer and closer to the people, for them to make those rights realizable for them, I think. Thank you very much.
Thank you, Commissioner Pisanqakula. And then I have Commissioner Makwanishe.
Thank you very much, Acting Chief Justice. Good morning, Judge Setiloane.
Good morning, sir.
No, I have one question for you. In 2004, you wrote an article entitled 8 Years at the Bar. And in 2006, you left the bar to join Waxman as in-house counsel. Were you disgruntled?
Was I?
Disgruntled.
Disgruntled?
Yes.
I was very, very involved in transformation at the bar, and the issue of briefing patterns was uppermost in all the minds of young counsel. Judge Mpofu was my colleague. He would know the debates we had at bar council level in relation to briefing patterns. When I started at the bar, my practice was essentially public interest law, constitutional law, public interest law. As time went by, I started breaking out into other areas of the law, competition, telecommunications, etc. But women were still not getting the amount of work that women were entitled to at that time. And black members, black women, black men, women generally were not getting the kind of work. So when I wrote that article, I I wasn't disgruntled, but I was disillusioned. And I said that I have never experienced that element of discrimination that I experienced with briefing patterns that I experienced in those 8 years at the bar. In those 8 years of the bar, we ran gender, sensitivity workshops. We invited attorneys to functions where we basically presented them with CVs of young people. We introduced them to young people. And the disillusioning part was they would brief those young counsel on one or two occasions, just, cosmetically, and thereafter they just return to their old positions again. I mean, by that stage, we also introduced the second junior rule, where if you didn't have a black counsel or a woman counsel on board, you had to bring one on. But of course, that benefited the very, very junior counsels in their first, second, and third years. I mean, by the time you were 8 years and above, you were actually left to your own devices. So I had a fairly busy practice, but I felt that I was not getting the commercial experience that I should be getting. So when Worksmans made me this offer to come and join them as in-house counsel, I decided to take that opportunity. But I always had at the back of my mind that I will come back to the bar. And while I was at Worksmans, I introduced a project whereby, it was Worksmans and a few other law firms, and I had to get special authority through the Johannesburg Bar from the General Counsel of the Bar to create opportunities for young women juniors to spend 6 months to a year at a law firm. So that basically allowed them to be exposed to the networks of lawyers that will assist them in their practices later on, So I wasn't disgruntled. I'm not disgruntled with the bar. The bar, the new bar, the Pan-African bar, members, they are all very close to me. They are my colleagues, they're my friends. They appear before me all the time. I support them in terms of their education programs, advocacy training, all of those things. But there was a problem with briefing patterns. And I see now, and it's encouraging, that more and more young women, particularly black women, are appearing in their courts. This mining charter matter. There were at least two women silks that appeared in the matter. And for the communities and the unions, you had about 4 women appearing, very junior counsel in under 4 years who did a superb job. So it's encouraging to see that those briefing patterns are changing now. I'm not sure that they are where they are, but they are
I
changing.
encourage you again, just Kathree-Setiloane, to try and not
Thank you, I'm done.
give too long answers. Yeah.
you, I'm done.
Okay. Are you done, Commissioner?
Yes, I'm done. Thank you very much. Chief
Thank you
Justice.
very much. I'm always happy when a commissioner asks one question. I'm making a note. Commissioner Matolo Mdlepu.
Thank you, Chief Justice, and good morning, Judge Setiloane.
Good morning.
When it comes to mentoring, I can vouch for you. You are always available for young women to be trained. But I just wanted to follow up on Commissioner Ngakula's issue on how do we, instead of bringing the constitutional and Bill of Rights to the people, how do you see the constitutional court actually maybe mentoring or offering learnerships to young practitioners? Because I see a lot of young practitioners really want to do constitutional law. They end up attending courses, but nothing. But I think the mentoring, like when you're a judge's clerk, wouldn't be a good idea, maybe probably like that.
Yes. The whole constitutional court program around the clerks is structured such that You get young lawyers that come in for a year, and I think they can only stay for a year, not more than that. So that ensures that, a number of young lawyers go through that program, which I think is very important for their development as young lawyers. But I think what you're asking me is, what do we do about young students at university, and how do we expose them to what's happening in the Constitutional Court? While I was at the Constitutional Court, one of Judge Zondo's clerks formed an organization called Sinako We Come. And basically what she did, and I think that's a fantastic idea, while she was a clerk at the court, she's now at the bar. She's now doing her pupillage at the bar. She basically used to invite students, high school students, university students from across the country, right? And she would then bring them to the Constitutional Court for a weekend. And she would then invite judges, and she invited me, I know she invited Judge Jafta and a few other judges to basically address these students, on why, on the work that the court does, basically demystify the Constitutional Court. And what that does, it actually instills in the minds of these young people that, you've got Justice Jafta, you've got Judge Mahora, you've got Justice Taran, you've got Justice Zondo. These are all people that were young students like you were. And, and look where they have come. So that, in their minds, inculcates the idea that I can also achieve what these justices have achieved, whether ultimately I get to the Constitutional Court, or I become an advocate, or I become an attorney. But, I think what this young girl has done is incredible. And I think she's won some awards for it as well. And I think that kind of program can be replicated to really bring young minds, people that are interested in becoming lawyers, into the court environment, and expose them to the court and to the justices and to the other young clerks.
Thank you. Thank you.
Thank you, Commissioner. Before I go to Commissioner Chepe, can I go to the commissioners who are virtual and see if anyone wishes to ask a question? Commissioners?
Acting Chief Justice Singh, my hand is up.
Yes, thank you.
May I proceed?
Yeah, proceed, please.
Thank you, Acting Chief Justice. I'm on the screen in front of you, Judge Setiloane. Good day to you. In your questionnaire that you completed on the 27th of November 2020, you listed that there were no reserved judgments, but you had 3 part-heard matters, some ranging back to March 2019, so it's more than 2 years now. There were 3 matters that you listed. What I'd like to know if these matters have been heard and concluded.
Yes.
And allied to the question of timeframes, a question was asked early on about, and from your experience in the Court, what is the average time you think the Constitutional Court should take to hand down judgment on a matter? And here I refer to one matter, where a court in the Western Cape, I think with Judge Magona, ruled that life partners are spouses for interstate succession. This was in October last year, and it's almost a year gone, and I don't think a judgment has come forth from the Constitutional Court. So what are your views on that? Timeframes and your part-heard matters.
Yes.
Thank you, Acting Chief.
Yes, on my part-heard matters, they've all been completed. I had to lead, I think there was just one. There's one where I've heard the evidence in all of them. There's one where I'm waiting for them to let me have the transcript and let me have the heads of argument so I can then prepare the judgment. So that should come now in this new term. So all of those part-heard matters have been completed. There were also delay because of, in March 2020, because of COVID. So matters from 2019 would have been dealt with in that 2020 year. But because we were still setting up our systems, and in relation to trials, it was particularly difficult, especially if it was a long-term trial. But all of those trials just needed about 2 days of evidence, and that's all been completed. One of them became settled.
No, thank you for that, Judge.
Yes.
And just the second part?
Yes, I think in relation to getting out judgments quickly, there's in terms of the code of conduct, there's the we are all required to produce judgments within 3 months. In Johannesburg and Pretoria, it's sometimes a little bit difficult to produce judgments within 3 months because of the workload that we have. So lengthy judgments, complex judgments, are kind of dealt with over the recess period. So sometimes it just goes over 3 months. But I think in the Constitutional Court, when I was there, I didn't realize from when I was a clerk there to the time that I acted in that court how large the workload of that court is. And particularly because it's dealing with these applications for leave to appeal all of the time. So apart from the hearings, they're dealing with hundreds of matters that come in virtually every month that have to be sifted and given to judges, and judges must decide whether these matters should have a hearing, whether there's grounds to grant leave. So there's the workload, I think, since 2016, 2017 has increased. Well, since the jurisdiction of the court has increased, I think, since that amendment in relation to extending the jurisdiction of the court to matters that extend beyond constitutional matters. So the workload is incredibly heavy in that court, but I think they could work quickly. Maybe judgments could come out sooner. It's very hard to tell because, in as much as we'd like judgments from the Constitutional Court to come out sooner, there's a lot of deliberating that has to happen. Sometimes there are more than one concurring judgment. Sometimes there are more than one dissenting judgment, So judges are drafting judgments that they get allocated for that term. They're drafting judgments that they were allocated before that. They are writing dissenting judgments. They're writing concurring judgments. So it's not like in the High Court where you just have a particular matter and you're applying your mind to it, or you're sitting in an appeal and you apply your mind to that and you can get it out within 3 to 4 months. I think it takes time in the Constitutional Court because of dissenting judgments, because of other concurring judgments, because of the workload that the judges are faced with. It's incredibly large workload. I was completely shocked at the workload that the judges face in that court. But I do think, going forward, I think they're also trying their best to get judgments out as quickly as possible. But circumstances, given the circumstances that they face, judgments are sometimes delayed. But I find it, I think simpler judgments, smaller judgments come out quickly, but it's the larger ones where there needs to be lots of discussion to bring everybody onto the same page. That takes longer, I suppose. Yes.
Just a quick follow-up, ACJ.
Yes.
So what you're saying, Honourable Judge, is what's good for the goose is not good for the gander. You've got a 3-month rule,
yes.
generally, but with the Concord, they can take as much time as they want.
No,
is
I
that
don't.
What you're saying?
I think it has to be a reasonable amount of time. I think within 6 months or so would be reasonable, I would say.
Okay, thank you. I've got an answer. Yes. Thank you.
Thank you. Commissioner Tsepe.
Thank you, Acting CJ. Good morning, Justice Kathree-Setiloane.
Good morning.
Welcome. I just wanted to ask you, do you think that the experience that you have, particularly acting in specialist courts like the Competition Appeal Court, would assist you were you to be appointed at the Constitutional Court, given the extended mandate or jurisdiction of the court? And if so, do you have examples where that have happened when you are acting there? Thank you.
Yes. When I acted in that court in 2017, I had not acted in the Competition Appeal Court, but I was given a complex competition appeal matter, the SOS support group matter, to deal with. And fortunately, I had some knowledge from when I was in practice, to put into that judgment. But I did a lot of research as well. I did a lot of research on it. I do think, I think having the extra labor appeal specialist experience from being in that court and the competition appeal experience will help tremendously in the competition appeal, in the Constitutional Court, because those two courts now on the same level as the SCA, and those matters come directly to the Constitutional Court on appeal. They don't go via the Supreme Court of Appeal anymore. So they're going directly to the Constitutional Court. So I think any judge that's appointed in that court should have sat in the Labour Appeal Court and the Competition Appeal Court. Should have that specialist experience. Yeah.
Thank you.
Thank you.
Thank you. I think I'm going to just mention this for the benefit of everybody. I'll get my staff to double check. I think the reference to 3 months that Justice Kathree-Setiloane is referring to in terms of judgments is what the judiciary has fixed as what they aspire to achieve, ideally. But it's not misconduct if you go beyond 3 months. You can still have more time. So I just want to I'll check when and I'll come back to it when I can say something more accurate. But I think the 3 months is just what we aspire to achieve one day.
Actually, acting Chief Justice is 8 months.
Oh, it's 8 months.
Yeah, 3
yes.
months is a warning.
Yes.
That is, you have to, parties
Yes.
can ask,
Yes.
but the judgment must be delivered in 8
Yes.
months.
Thank you, Commissioner.
Yes, I know in the High
Commissioner,
Court.
I wanted to double check. I was thinking 7 or 8 months, but I wanted to double check. Yeah. Okay, all right. Thank you. Then Commissioner Madonsela.
Thank you, Acting Chief Justice, and good morning, Judge Kathree-Setiloane.
Good morning, Mr. Matinsela.
It seems clear to me that there is some consternation around the delays in judgments, especially from the Constitutional Court. And you and some other candidates have sort of tried to tread carefully in trying to give explanations for it. But hopefully, we don't have to tread carefully because we're not aspiring to go to that court.
Okay.
As matters currently stand.
Yes, understandable. Yes, yes.
Maybe the chairperson must get out of the room.
Now, if we were to confront the problem, and if you were to be appointed in the Constitutional Court, given your understanding of the workings of the court, having been a clerk in that court and having acted in that court, how would you seek to address the problems associated with quick delivery of Constitutional Court judgments? What do you think is wrong with the Constitutional Court just giving out quick judgments with no theses that are written by various judges who differ on particular topics? That's one aspect of it. The other aspect of it, you have mentioned the question of applications for leave to appeal, which are also occupying the court outside of the sittings of the court. How can one alleviate the burden of the justices of the court in dealing with applications for leave to appeal, which seem to be coming in numbers now that the jurisdiction of the court has been enlarged?
Yes. I mean, I think I think it's important to try and get consensus in these judgments to the Constitutional Court, but it's not always possible. And I think those judgments where there's consensus, those judgments are delivered, fairly soon, within 3 months, I think, from my experience. Things just where there's dissension amongst your colleagues, that takes a little bit longer. But I do think that there's a whole register when you go to conferences on a Wednesday. It's so when you are allocated a judgment, you are then, from the date of the hearing, you're given, I think, 3 weeks, 15 days or 21 days or something to produce you're first given 7 days. You're first given 7 days to produce your memorandum, okay, setting out your views to your colleagues. And then once your memorandum is in and once your colleagues have responded, and the colleagues also have a period of about 4 to 5 days, or could be 7 days to come back to you to tell you what their views are, whether they agree or whether they not agree. And you know basically from those responses from your colleagues, you know, which way, whether they're going to agree with you or not. Then, you know, from that date, you've got, I think, maybe 15, and Judge Zondo will, Acting Chief Justice Zondo will correct you. You probably have, I think, 3 weeks, Acting Chief Justice Zondo, to produce a draft, okay? You then produce the draft, and sometimes because of I found that sometimes because of the workload, your colleagues don't come back to you immediately on that draft, you know. Maybe if it's a high-profile matter and there's a need because the public are waiting for the judgment, that'll happen. But I think other matters can sometimes take longer. So that your colleagues sometimes only come back to you in a month's time or 2 months' time. Or some colleagues will come back to you within the 7-day period, you know, with their comments on your draft. Some other colleagues take longer. So I think you can actually try and bridge those periods, time periods, you know, and make sure that each of the judges keep to those time periods that are set out. Because they very carefully, one of the judges takes responsibility for this register. And I know it was between Judge Cameron and Judge Turan when I was there. They would, you know, every day, every Wednesday conference, they would basically insert that, you know, this judgment is due on that day. And when you've given the judgment in, and if you haven't, then they'll remind you at the conference. But sometimes circumstances, you know, depending on, you know, the other thing with the court is, and we have to understand, given all of these matters that they asked to deal with by way of direct access or otherwise, matters on the basis of urgency, etc., those matters actually interfere with their workload in the regular caseload of that court. Because every term, the 11 judges get 1 judgment to write, you know. And maybe you'll get a smaller judgment to write that arises out of matters where there are no hearings, but you will produce you may still produce a judgment. Yes.
I understand the bureaucracy around the production of judgments, but my problem is, and I want to hear you on what the solution should be. Shouldn't court just simply write quick and short judgments?
Yes.
Or shouldn't the court employ people to assist in considering the applications for leave to appeal so that we have a quick turnaround time?
Yes.
That's what I want to hear. I don't want to hear
Yes. I mean, I think with
problems
the
themselves.
applications for leave to appeal, the clerks are already there. The clerks draft the first memorandum in the application for leave to appeal, and then the judges then basically work on that memorandum before it's sent out to your 10 other colleagues. So there is already assistance from the clerks, you know. Clerks are also there, and they're also assisting the judges with research in the judgments. So I think that I think you can actually speed up the process. I think maybe there has to be a concerted effort to actually speed up the process and maybe hold judges to the deadlines that they're given. I think if you hold them to the deadlines that they're given, and unless there's a convincing reason for not meeting that draft, you know, a judge must be told, no, you need to produce this within that time limit because everybody gets the same time limit. So I think you can work quicker. I think maybe that's the culture. The culture needs to change.
I think you can hold them to their deadlines. I know that.
Yes, I think you can hold them to deadlines. And I think in some cases you don't have to go into a whole exposition of the law and repeat, you know, what the High Court stated 15 years ago. The Constitutional Court, you basically hone in and, you know, in developing the law, you develop the law. You don't have to do it in 45 pages. You can do it in 10, 12 pages. And I know that judges are being encouraged to write shorter judgments. I mean, we certainly were encouraged to write shorter judgments when we were there.
Thank you, Judge Kathree-Setiloane. I have Commissioner Shabangu Mdawe, Commissioner Nochesi, Commissioner Malema, and Commissioner Schlema. I propose to stop with these. We are running behind time. Okay, Commissioner Shabangu Mdawe, and I'll always be happy if a commissioner says one question only.
Thank you, ACJ. I'm going to be very short. In fact, I want to make a follow-up on the question asked by the minister. Good morning, Judge Setiloane.
Good morning, ma'am.
Let me first start by commending you by taking that matter of the LGBT community back then in 2005. It was not an easy task to represent that community. Then, looking back then and now, has anything changed with regards to the rights of the LGBT community? Are our courts protecting the rights of that community enough? Should you be considered? What is it that you will assist so that the rights of this community are protected?
No, I think in terms of the rights to marriage and I think inheritance, in terms of succession, all of those things, adoption, surrogacy arrangements, in vitro fertilization, adoption. I mean, they've attained a number of rights through the years, through the High Court right up to the Constitutional Court. And I think for me, and the concern that was raised by the minister is the question of violence against members of this community. And the same goes for women, How do we ensure that endemic violence that this community faces comes to an end, And what can we do as a society? What can we do as government? What can we do as courts to basically ensure that there's full protection against violence for these communities?
Thank you.
Thank you, Commissioner Shabangu Mdawe. Commissioner Njesi.
Thank you, Chair. I've been covered. At least let me oblige. I've been covered.
Thank you. Oh, you make me happy. Commissioner Malema.
I'm not about to make you happy
just
now.
go straight to the point.
I want some sense of clarity. Yeah, people make an application for rescinding judgment in the Constitutional Court, and they are made to run during weekend, and the matter is heard quickly. An impression is created, correctly so. There is an uncertainty in the country. That's how urgent that matter is. There is uncertainty in the country. Things are burning, literally. And when we grew up, we're told that an urgent application means that someone is about to lose life. There must be an immediate intervention. When that impression is created, the matter is heard, the Constitutional Court takes forever to come back to us with so much uncertainty. How do we deal with that? Is that enhancing the good image of the judiciary? And if not, who is going to be held accountable? Are there mechanisms to hold Constitutional Court judges accountable? Because an impression must never be created that the Constitutional Court judges are above the Constitution. They too are subjected to the Constitution. How do we deal with that?
Yes, Mr. Malema, I understand the frustration that was attached to basically waiting for this rescission judgment to come out. It took quite a while. I do believe when the court deals with the matter on the basis of urgency, it then must apply the requisite urgency in producing that judgment. I mean, we do that in the High Court. We have highly complex matters. And though sometimes these are the same matters that go to the Constitutional Court. And we produce judgments within a week or two, sometimes the very next day, So I do think when the matter is urgent, then the court must then apply itself with the requisite urgency in producing the judgment.
Thank you.
Thank you, Commissioner Malema. Then it's Commissioner Schlemmer, and I think she would be the last one.
Thank you, Acting Chief Justice. Good morning, ma'am. It's almost afternoon. Yes. I'm sorry for keeping you so long. I just want to ask you one question, and that relates to the appointment of justices to the Constitutional Court. You mentioned during your interview a couple of times the fact that one needs additional type of knowledge, that you actually need to act in the Labour Appeals Court as well as in the Competition Appeal Court. Yet the Constitution has not been amended as yet to make provision for such requirements. How would you suggest that the Constitution be amended, and what would you require of Constitutional Court judges if you were to write the amendment to the Constitution?
Yes. I mean, I think, I don't know if you need an amendment to the Constitution in this respect, but I think it's advisable and it's appropriate to appoint judges that have had appellative, experience before. I think it's important. I mean, in the past, you had academics that came directly to the court. I mean, they did superbly, but things are changing now, and I think you need a lot of procedural knowledge, for a judge. And given that the Constitutional Court is now dealing with a larger subject matter than constitutional issues, you need to have the broader knowledge that a High Court judge would have, or a Supreme Court of Appeal judge, or a Labour Appeal Court judge. I'm not sure that it requires an amendment. I just think it's advisable when this commission appoints judges to ensure that the judges that are being appointed have experience across the field, and so commercial law, competition law, labor law, all areas of the law. In fact, you need to have broad experience, and I think that experience comes with serving a lot of time at the High Court, serving time at the appellate court. So I don't know if an amendment is required, but certainly I would say that when appointing members to the Constitutional Court, you need to have judges that have all-round experience, basically.
Thank you.
Thank you, Commissioner Schlemmer. Commissioner Mpofu has asked for a small indulgence. Commissioner Mpofu.
Thank you, DCJ. I'm so sorry to you, DCJ, as well. I meant to do a quick follow-up in the answer that you're giving me. You said that unlike in other courts, nobody comes to you or to your chambers to seek to influence which way you should go in the Constitutional Court. Can you tell us what you meant by that? Just briefly.
I don't think it wasn't meant in a malicious way. I just think that in the High Court, we often talk amongst ourselves before we go into an appeal hearing. In the SCA, there was a practice that you shouldn't talk amongst yourselves before you go to a hearing, but I don't think that was strictly complied with. I think colleagues did walk into your chamber to try and elicit your view on a matter. I think that happened from time to time, which I was surprised. I was once in the lift and two colleagues were speaking about a matter that I was going to be in. They were talking about it and which way they're going to be, which way they think they should go. And I was standing there as an acting judge, completely silent, not even wanting to lend my ears to that conversation because I was told strictly you don't discuss this with other judges. That's all I said. There's no pressure on the Constitutional Court to go in a particular way or not to dissent or anything of that sort. Really nothing at all.
Thank you, Mr.
Thank you, Commissioner Mpofu. We are done. Thank you very much, Judge Kathree-Setiloane, for having made the time to come. We have come to the end of the interview. But before I release you, I would like you to be with us when we do what we are going to do now. I've been advised that it would be appropriate for us to have a minute's silence as a tribute to Commissioner Sigogo, who passed away. So if everybody agrees, may I ask that we all stand and have a minute's silence. You are now excused,
Thank you.
Judge
Thank you.
Kathree-Setiloane.
Thank you very much.
Thank you.
Acting Justice.